Hi everyone. Okay, so let's go through this order. It's only 2 pages, so it's going to be quite a brief video. Okay, so this came out, when did it come out? The 21st, so yesterday. Okay, order on plaintiff's motion for a preliminary injunction and defendant's motion to dismiss plaintiff's complaint. Before the court are plaintiff Marine Flagg's motion for preliminary injunction. That's basically like to, temporary injunction to stop Taylor Swift using the life of a showgirl, basically, while this matter is still being decided by the court. Defendant's opposition and plaintiff's Flagg's reply and response to defendant's evidentiary objections. Defendants filed a motion to dismiss the complaint and noticed the hearing on the motion for August 5th, 2026. May 27th, 2026, the court held a hearing on plaintiff Flagg's motion for a preliminary injunction. Thereafter, plaintiff Flagg filed a first amended complaint, to which defendants then filed a motion to dismiss the first amended complaint, with hearing noticed for October 7th, 2026. So it just cites a case there of Ramirez. It is well established in our circuit that an amended complaint supersedes the original, the latter being treated thereafter as non-existent. One of the principal inquiries raised by motions for preliminary injunctions is whether the moving party is likely to be successful on the merits of the action. Okay. But when I go scroll past some of this, they're just citing little parts of various judgments. Because an analysis of whether preliminary injunction should issue involves reference to the movement's claims, their sufficiency, and the evidence submitted in support, new allegations and claims significantly alter the preliminary injunction analysis and would therefore moot such request. Accordingly, the court orders as follows. So, firstly, the parties shall file a joint status report as to why the court should not deny as moot plaintiff Marine Flagg's motion for preliminary injunction. Considering plaintiff has filed a first amended complaint. So this is going to be similar to, if anyone was following the Lively Baldoni and Lively Wayfarer case, when the New York Times wanted the judge to basically formally declare that they were, successful, so they could kind of move on, pursue costs and fees, etc. There was a whole thing, where Judge Lyman asked the parties basically well, can you all file reasons as to why I should deny this? And no one did. No one opposed it at all. Lively did file something. It was like, yeah, but when you do this, can you also do that for me, kind of thing, And she wanted to basically put a stop, a pause, not a permanent stop, just a temporary pause on Wayfarer being allowed to appeal until the judge had ruled on her Section 47.1 motion for damages and remedies. Which Lyman granted. It wasn't an unreasonable request, and it didn't prejudice Wayfarer in the slightest. But basically, they're looking for the same thing here. I can deny this motion for preliminary injunction as moot, given that she has now amended her complaint. So the motion for preliminary injunction was based on the original complaint. Well, now that no longer exists, it's been replaced. Ordinarily, they would then deny the motion for preliminary injunction, and this judge is saying, right, tell me why I shouldn't do that. So they've got to file this joint status report on or before the 3rd of August. So we will find out, Marine Flagg may just let it go and go, no, do you know what, or file a new one. Or she may argue, no, Judge, don't deny it is moot, and here's the reasons why, and we'll find out, obviously, at the latest by the 3rd of August, what's going to happen there. Taylor Swift may do nothing because she doesn't have to do anything. Because I'm sure she would want to see it denied. Or she may do a lively and just, file something anyway, just to say, Judge, no, you should actually do this. You should definitely deny this. Just to kind of reaffirm or re-argue a little bit why it should be denied. And then the second part of this order, defendant's motion to dismiss the complaint denied. And that is obviously for the same reason. The motion to dismiss was filed against the original complaint. The original complaint has now been amended, so the original complaint is now null and void, which they're obviously aware of because they've already filed a motion to dismiss, which was my last video. So that's where we are on this. We are waiting for this joint status report over the preliminary injunction, but also for Marine Flagg to respond to file an opposition to the motion to dismiss. So, we haven't really got any very far in this lawsuit, and I can see this already just racking up so much in legal fees, and it'll be quite devastating, really, if one of these parties, if Marine Flagg loses this and then Taylor Swift, applies for her fees, which I think she will try to do and may get. But they haven't lost the case yet. I still think it's a good case, so we will see where this goes.